So welcome again. Today's webinar is going to be surrounding the topic of construction and how to protect yourselves from liability on site in terms of theft, property damage, so on and so forth. We've got a great panelist joining us today. We'll jump into that here shortly, but I want to go over a quick agenda. We'll start off by doing some introductions. We'll go over an overview of the problem and the issues on site, and then some of the legal risks that you're faced with, and then some of the security and mitigation and how to prevent and protect yourself. Then we'll end with a Q&A. That means that if you guys have any questions come up during the discussion, don't hesitate to throw them into the chat. We can cover them as we're going through everything. So go ahead and throw them in as they come up. So my name is Jen. I started off on the operations side in the multifamily realm of things, working with property managers and regionals. So I'm familiar with what is dealt with day in and day out in terms of security issues, property damage, lease violations, that kind of thing. But it does kind of flood over into new development for the multifamily realm, which does include construction sites and everything like that. I'm now with Cloudastructure, which we work with AI surveillance and remote guarding. So we're more of the proactive side of security, but my passion is really in getting the word out on how to really protect yourselves and create that proactive approach to security, which will, in the long run, only make your job easier, save you a lot of money, save you a lot of time, and the headache of having to deal with theft, property damage. So very happy to be here and lead this conversation. And then we also have Adam Edgecom, who is a partner with Cobb and Gonzalez. So he is a leading litigator in construction law and subject matter expert in liability law. So we're really excited to have you here, Adam. Thank you so much for joining us.
Sure. Thanks for having me.
So I spoke a little bit about Cloudastructure, but to dive into it just a little bit more, and then I'll touch on some of the products that we have later on in this call. But again, I've said that proactive word a couple of times. That's what really separates us from standard security. So we're adding in that speaker, that real live talk down of implementing that incident right when it's happening. So we have held strong with a 98% deterrence rate since 2023, and we're really proud to be able to say that. So utilizing our advanced AI analytics and that remote guarding feature really comes together to create that proactive approach to security on your construction sites. And so it's something that's super helpful. And again, the ROI that you'll see in implementing a solution like this is huge. And we'll cover that a little bit later, but really excited to kind of share what Cloudastructure has to offer. And then Adam, if you could tell us a little bit about Cobb and Gonzalez, that would be great.
Yeah, we were founded in 2019. Several of my partners and I, including Cobb and Gonzalez, who founded the firm, we all worked together at a previous firm and kind of found our way back here together to practice. We do just about any kind of civil issue, but we really focus a lot on construction. And I do a lot of construction, a lot of landlord tenant, all kinds of other areas of law. Eventually bleed into both those areas. So this is kind of right in the wheelhouse of what my clients have to consider and deal with on weekly, if not daily basis.
So we're really excited to have you here to share your expertise, your knowledge. I know you have a lot of stories to share as well. So again, thank you for taking the time to join us this morning. All right, let's go ahead and jump into it. So first and foremost, we want to kind of cover some of the data surrounding some of the statistics with theft on site. So we've collected some data and it's huge, guys. $1 billion of equipment is stolen annually from construction sites. So in terms of on a weekly report, 21% of contractors report weekly theft. 63% experience theft at least once monthly. That's huge. That's 1 in every 2. 92% report annual problems. And the average cost of the theft each instance is about $72,000. So the amount of liability that comes into play with dealing with theft on site is huge. Only 21 to 25% of stolen goods are recovered, which I know Adam has a story to kind of talk about this a little bit later as well. But Litigation over theft most often occurs when there's an ambiguity over job site control, insurance coverage, or payment for stolen materials. So that all comes into play when we're talking about that. So Adam, I'm curious, do you have, kind of a high level story to offer of what you've seen in litigation and how those cases tend to shake out in court and in whose favor and so on and so forth?
So, in my personal experience, in my practice, exclusively what I've experienced is materials, wood, copper, wiring, things like that being stolen. They can easily be sold on the black market. A lot easier to run away with materials than big equipment and things like that. But those types of thefts absolutely do happen. Just thankfully, knocking on wood here, none of my clients have ever faced that before. There is a pretty well known story here in Florida regarding a big commercial site where someone stole, I guess, some kind of equipment, not a backhoe, but the equivalent of something like that, and went and stole an ATM using that stolen equipment. And so that, just aside from being like kind of crazy, it just kind of brings to bear, really reinforces the extensive liability that can happen. And thank you for whoever said it was a backhoe. Thank you for that. While stealing that backhoe, if that thief had run over someone, or in addition to the ATM, maybe they took a chunk out of the side of a building or something, all that liability is going to ultimately fall to whomever at the construction site was potentially liable for allowing that theft to occur. And then one of my own clients, they didn't have anything, but when I was kind of asking clients for their experiences with these things, one of my big commercial glass supplier clients mentioned that they were on a job where a substantial over six figures amount of machinery was stolen, and that was all rental equipment. And so that had substantial cost for that sub that got that equipment stolen. And other part of your question, Jen, in my experience, exclusively in my experience, and I would say anecdotally, most thefts probably don't end up in court because, in my experience, most good commercial contracts are going to have clear contractual language about who is liable for securing the site, liable for thefts, things like that. And so if you have good tight contract documents, unfortunately, someone's still paying for that theft, but it's at least going to probably keep you out of court.
So obviously, so many factors come into play here, not even just the amount of financial loss if something is stolen, but also the liability that comes along with it due to
Yeah.
property damage, someone getting injured or hurt, which kind of takes us into our next slide here. So talking about premises liability and duty of care. So most people assume if a trespasser gets hurt on their job site, they're not responsible. But I know state laws come into play here and the foreseeable risk concept. How do those apply in those kind of cases?
I mean, high level, normally, at least in my experience, and it is going to be state by state, but certainly in Florida, if you're a trespasser and you fall in some hole or something and break a leg, you're trespassing. The landlord owner owes you no duty at all. But that's certainly not going to stop a personal injury attorney from potentially suing you, and you having to pay them to settle out and get out of the case, maybe have a claim against your insurance. Even though you can think you don't have liability to trespassers, you still really have to think about that. And foreseeable risk, that really goes to the other categories of property visitors, licensees and invitees. And basically, if there's a foreseeable risk, and certainly a risk of or should know of, then you're going to want to let folks know about that foreseeable risk. And so it basically, foreseeable risk, kind of as the name implies, if it's foreseeable someone could get hurt and they are on your property properly and permissively, then you need to make sure you're advising them as to foreseeable risks, making sure that your property is in a reasonably safe condition. And certainly that attractive nuisance doctrine there, that also kind of plays into all of this. As folks may have heard of that concept, when I think of attractive nuisance, and certainly in construction, what always kind of comes to mind for me me is just like a huge pile of dirt or the equivalent. You see those on construction sites all the time. And, you as a contractor or sub may be thinking, well, I can leave this big pile of dirt here outside the fence of the project. No one's going to come steal this 12 tons of dirt. But as a kid, my friends and I, we'd love to play on those things and dig in them and things. And so somebody could, on a construction site, even if you're just playing around on dirt, you could still get hurt. And so, something that can potentially hurt someone, the law is going to think of that as a nuisance. And then it's attractive in the sense that somebody, whether they're a dummy or not, or a child or not, that nuisance draws their attention. They're interested in it. They want to go check it out. It could even be like last night I was trying to think of some examples. I came up with some crazy ideas, but this would never happen. But if you had some huge pile of colored glass that had been removed from a project and it was, just stacked in a big pile or something and broken, maybe the sun hits it and it looks all pretty and somebody goes over to look at it and ends up cutting themselves on it. That's kind of what attractive nuisance is there. And you definitely want to make sure with respect to those things that you have them secured. And that is, in my view, if there is something that is an attractive nuisance, that's where surveillance is really going to come in handy. Outside folks who shouldn't be on the site. And so that to me is probably one of the biggest concerns is if your project has some kind of attractive nuisance, making sure that's not just locked away where the public can't get it, but where immediately if someone has accessed it so that you're not then dealing with some kind of personal injury claim or a death or catastrophic injury, something like that.
Even though it's your property, people will find a way onto it, and especially if it's that attractive nuisance. I like your analogy of that colored glass because, I mean, if it looks like something that's pretty, why not go check it out?
I've got friends who are, they're very artsy and crafty, and plenty of times folks throw stuff away and it's on the side of the road, and they're like, I'll take that and fix it up, do whatever with it. Certainly, just using that glass example, I mean, you could see someone might want to come and try and access it, and or even take, oh, this is someone's trash, and take it away, and then all of a sudden you wake up the next day to some demand letter from ambulance chasing attorney trying to shake you down for a couple 100,000 or something. Certainly seen analogous situations.
All right, so that kind of takes us into our next slide here. So talking about contractual liability and indemnification. So we often hear disputes about who pays when theft occurs. So if you could kind of cover what some of these words mean, and then also
Yeah.
what specific contract language do you recommend to clearly define who bears that risk?
So hold harmless and indemnity are more or less the same thing. So both of them together, you're saying I've incurred some kind of loss, but some other party, usually a subcontractor, or if I'm the owner, then the GC, you have to actually bear the burden, the liability of that loss. And so indemnity is when if I'm a GC, hey sub, you screwed up, I had to hire a new sub and I paid them, an extra 20 grand, you have to indemnify me. I've already come out of pocket for that. Hold harmless is just sort of an earlier way of getting that money where you say, hey, I'm going to have to hire this person and it's going to cost 20 grand. You need to pay me now and hold me harmless. It's a way of shifting the risk to someone else. Indemnity versus hold harmless just kind of depends on when you make that demand for the payment. And so as y'all in attendance may appreciate, and as the presentation points out, in every project, you're always trying to have that risk flow down. If you're the owner, you want the GC to carry all risk of losses, whether it's thefts, injuries on the job site, things of that nature. If you're the GC, you're going to want to push that down on the sub. And in my experience, usually that is kind of what happens is the contract between the owner and the GC will say, hey, things get stolen or there's a personal injury on the site. Then I, as the owner, am not coming out of pocket. That's on you, general contractor. And then usually the GC's subcontracts will say exactly the same thing. If you cause some injury, whether or not it makes me as GC liable to the owner, but sub, you cause any kind of injury, you're paying me for it. So, it is just a way to shift that risk. And I wouldn't say necessarily it's any specific or like boilerplate language. It's just that language needs to be very clear, very concise. You'd be surprised sometimes terms like that don't even make it into the contract. So you need to make sure they're in the contract, make sure they're clear and concise. And then, another kind of hurdle, roadblock, pitfall that folks run into is if you're the GC, once you have that tight language with the owner, making sure that similar language that also works with your contract with the owner, that you have similar language in your subcontracts and that those marry up and, are in harmony. So if, again, as y'all may know, on most big commercial projects, the subcontracts are all going to say that if you as sub take on the same liability that I as GC take with regard to the owner, but sometimes that doesn't happen. And so it's, not, sorry to kind of repeat myself, it's more about just making sure you are addressing this issue and that it is in the contract. And then that when it is addressed, that it is clear and concise and all the terms of the various documents work together. And including in that is going to make sure that potentially, if you're an owner, that the GC has proper insurance. If you're GC, making sure the sub has the proper insurance, getting those certificates of liability, making sure they're kind of in harmony with your indemnification or hold harmless clauses. I truly almost bores me talking about it out loud now, but they are, unfortunately, they're very important clauses that can have, it's one of those things that maybe at the time you're signing the contract before the project starts, it doesn't seem that important, but 6, 7, 8 months down the road might make or break your entire project.
And I'm curious, in your experience, how often do indemnity clauses or hold harmless provisions actually protect the party who thinks they're covered?
Well, let me think how to answer this. I'm going to say about maybe 50-50, but it's not because of how the clause it was drafted. It's just the practical situation of I'm a GC and I'm some big, very successful commercial GC. I got some drywall sub on the project who screws up big time. Maybe he has insurance, maybe insurance doesn't cover this, but I've got a buttoned up indemnity and hold harmless provision. Okay, great. I can make demand on him, but if he doesn't have the money to pay me, or if he just says, screw you, I'm not paying you. Unfortunately, it doesn't matter how great, well, it does matter how great your clause is drafted because you're going to end up in court and you got to argue over it. But pre-trial, pre-filing a lawsuit, it doesn't matter how well your provision is drafted if that person just simply can't pay you. And so that's another reason or kind of another angle for insurance to factor in and making sure your insurance coverage is there and additional insureds and things like that.
Okay, that makes sense. Obviously, some extenuating factors. And you mentioned obviously making sure that they're clear and concise. Are there any other common mistakes that you see in how they're written?
Well, actually, that's a good question. So, and again, I'll try not to get too far into the kind of nerdy legal weeds here. But I know as an average person, you look at a contract and you're like, why does this one sentence have from A to Z every possible scenario addressed? Well, unfortunately, that sometimes comes up. And what I mean by that is, at least in Florida, let's say, a big part of indemnity and hold harm attorney's fees. Well, if your hold harmless and indemnity clause just says you're going to hold me harmless from attorney's fees, well, okay. In Florida, that actually has kind of a narrow scope. If there's a bankruptcy proceeding comes into play or an appeal, unless your indemnity clause specifically calls those out, you're not getting fees for those. There's a process where in Florida, when you're claiming fees, you first have to establish that you're entitled to the fees. Then there's a whole pretty long and fairly expensive process to determine the exact amount of fees you're allowed to recover. And if your indemnity clause doesn't say that you get fees for proving your entitlement to fees, then you're potentially going to show up for a full day evidentiary hearing, almost a trial, and your client isn't going to get fees for that. So hopefully it made sense when I was saying when look at a contract and you're like, why does this have so many different elements or situations included or what have you? It's because, unfortunately, we as lawyers are very nitpicky. And if you don't have sometimes those magic words in there, some lawyer out there is going to screw you over. So sometimes, unfortunately, you just have those ridiculously long clauses that seem to contemplate every scenario under the sun. Unfortunately, they sometimes come into play. So just making sure you really do have all the bases, every single angle or area of recompense, compensation you're going to want, you need to have that in that clause. You can't just say, hold me harmless from all claims. That probably you're going to miss out on some things.
So basically, consult your legal counsel.
Yes, yes.
And make sure that they're good quality legal counsel. Yes. Okay. So we have a question from Q&A. If a subcontractor's insurance lapses mid-project and theft occurs, does the GC's policy automatically step in?
Probably not. That'd be kind of a fact specific scenario. What practically speaking, if something was stolen and it's the sub's liability and their insurance lapses, that's still going to be on them. It's just now they're going to have to come out of pocket rather than having the benefit of their insurer pay for that. So unless the contract has some, provision that, and I'd be surprised if it had it, that says, sub is liable for theft unless insurance lapses or he can't pay. That's about the only time I would think that would probably bounce back on the GC.
Let's go ahead and take it over to negligent security. So negligent security claims, they can be devastating. So in theft related lawsuits, what typically triggers a finding of negligence? Is it lack of lighting, signage, fencing, failure to respond to risks?
Again, it would probably mostly be a very fact specific inquiry. Lighting, for instance, if the project was in a big urban area, Manhattan at night, that's still pretty well lit up. Now, if you're in downtown Jacksonville, unfortunately, at 2 a.m., not going to be nearly as lit up. So maybe it should have been more lit. Maybe it should have had fencing put up. Maybe you should have had, going back to the attractive nuisance, maybe it's some project where folks are, for instance, for whatever reason, when the Jags have been, or was either here in Jacksonville or maybe it was actually in Buffalo, somebody was doing work on their stadium and people kept climbing the fence and like falling into this huge pit. Actually, it was in Buffalo. And so that's a situation where I know already two or three people have accessed this. Well, clearly, whatever I have in place isn't enough. I need to get a tall to get round the clock human security or virtual and video, but it's really just going to be very fact specific as to what you might be negligent in not doing. But certainly it is going to fall to security guards, signage, things of that nature. Those are all going to be things that the law and the court is going to look at to determine, did you uphold your duty to keep this site safe and keep people out and from injuring themselves.
Yeah, and so we listed out some additional penalties here. Could you kind of go over what those are and what those mean?
As far as like OSHA penalties and things like that, your workers get hurt, and if it's because of inadequate security, that's going to potentially really have some bad problems for you as a GC. The breach of contract, if the owner has supplied appliances, machinery, equipment, things of that nature, and somebody accesses the site and steals it, and contractor doesn't pay for that, that's probably going to be a breach of contract. But really, the biggest, this last bullet point, in my view, is the biggest, just because it deals with that insurance, and whether it's personal injury, theft of equipment and things like that, that is really going to start to complicate your ability to obtain insurance, and certainly the cost. And that is going to drive so much. I mean, if you can't be properly insured, you can't take on big jobs that you want to. And, I even know, certainly from my clients, that even bogus claims that end up, getting denied and not paid out, just the fact that they're making that claim and it shows up on your claim run, that's going to increase your premium for the next year. So these things, they just kind of spiral out and just generate out from that original theft. The consequential damages from that can just kind of reverberate. That was the word I was looking for, can just continue out in ways that you may not have ever foreseen.
And obviously, court cases can take months, sometimes years to get resolved. So that
Yeah.
means, witnesses leave, their memories fade. How could an owner or contractor really ensure that their case is still valid after?
Yeah. Huge concern for us as lawyers is like, hey, this may be obvious to us as we sit here in an office or something, but That doesn't mean it's obvious to the court, and you've got to prove that. And exactly to your point, memories fade, employees leave, and so documentation is always your best friend. That was 4 years ago, and the employees left, but I have this document that was created on the day of the theft, laying out exactly what happened and who was there and whatnot. That's certainly going to help, but of course, having it on video is always going to help because that's going to show exactly what occurred, who did what, when, and where. When I say documentation, that's not just papers like this. It would also be video and making sure you have an accurate record that you can go back to that is not going to change with time the way people's memories do.
Yeah, very important documentation and surveillance. That
Yeah.
kind of leads me into this next question, which selling cameras and selling surveillance, I get asked this quite often or get the objection that they don't want the additional liability. So
Mhm.
if a contractor installs cameras or other monitoring systems, but they don't actively watch them, could that actually increase their liability rather than reduce it?
Not like as a matter of law, but certainly just sort of as a practical consequence, if you have the cameras up there, going back to the attractive nuisance situation, if you're just monitoring the cameras after the fact, you're literally being reactive and you're dealing with the fallout. If you have someone monitoring the cameras, that gives you a bigger, much better chance of stopping that conduct from even happening or lessening the severity of that contact, or excuse me, that conduct, as opposed to, okay, well, we know we were robbed or we know someone got hurt. And okay, now we know how it happened when we went back and looked at it. But again, going back to that attractive nuisance situation, if you've got someone monitoring that camera and realizes, oh, hey, there's a bunch of kids up on this 30-foot pile of dirt on the side of a cliff for some reason, somebody actively monitoring that can jump in and, hey, y'all need to get out there, shut this down right now. And also, certainly like large theft, not just someone walking off with a pallet of wood or something, but, someone trying to take equipment from a site, that's going to take some time, 20, 30 minutes, I would guess. I'm not a thief myself, so sure, but so if you find out after the fact, okay, that's the guy who stole it and this is when he stole it, okay, great, go find it, go find that guy and get it back from him and hope he still has it. Okay, that's, I guess, better than nothing. But what I'd rather have is active monitoring where that guy didn't even get away with my equipment and, he stopped right then and there and I get to keep my equipment and not chase it or have to make my own insurance claim or fight with a sub or an owner about who's liable for that.
Yeah, I mean, you just said it right there. Taking your security from a reactive approach to a proactive approach just saves time, money, effort, headache, everything, and protects your.
Yeah.
So, if you had to give one takeaway to general contractors and owners to protect themselves before the next theft happens, because it's just a matter of time, what's the single most effective legal or contractual step that they could take right now?
Contractually, I think it's just making sure your contract shifts that burden to someone else. And like I mentioned, making sure that whomever that's shifted to actually can bear that burden, has the money, has the assets to potentially, has the insurance to potentially pay you back. And, just as far as kind of practical steps, from my view, it's everything we've been talking about. It's know your project, know the potential risks, know the supplies and equipment that might be attractive for thieves. 10, 15 years ago, I know copper wire was super, super hot to steal, and just understanding your project and the details and why it might be attractive to a thief and then taking the appropriate steps. At a minimum, I feel like every project should probably be fenced off. But, for those bigger jobs and with a lot of expensive equipment and potential for injury, like we just talked about, I think cameras and potentially actively monitoring cameras is going to be a very good step to reduce your liability and keep those costs down.
So here is just a really quick video that kind of highlights one of the products that Cloudastructure has that really will create exactly what Adam just said would be beneficial for the property, that proactive monitoring of construction sites. So let me go ahead and play this here and then we'll chat about it.
Cloudastructure, in partnership with Flex Security, is proud to introduce Alpha, Alpha provides 24/7 365 power, ensuring 100% uptime with 880-watt solar panels charging 600 amp-hour battery banks, with backup power generation from our lightest and most efficient Flex Power 2800i generator. Alpha comes equipped with 3 high-definition PTZ cameras on board, Cloudastructure's AI analytics, seamless monitoring software, as well as cloud services and storage. Alpha monitors every critical moment in real time, managing from anywhere with Cloudastructure's remote guarding services, keeping you in control of power usage and security management, all viewable from your device anywhere in the world. Stay connected with 5G, Wi-Fi, and even Starlink options. Need live monitoring? Cloudastructure's remote guarding services stop crime in real time with a 98% deterrence rate. Don't just record crime, prevent it with Cloudastructure. Discover more about purchasing or leasing options at cloudastructure.com.
So that is the solution that we have for construction sites or any site that is really faced with lack of power, lack of network. And so, as you heard, they're powered by solar, and there's even a backup generator for those instances where there might be a storm or there's cloud cover or anything like that. And then they're also equipped with a modem and a SIM card for their own internet. So there's connectivity at all times, and even Starlink in those areas where there's not much connectivity. So being able to have that surveillance and coverage of your construction sites, but also that proactive approach of our remote guards that are able to talk down over a speaker and say, hey, you're in a monitored area. Or as Adam mentioned previously, if there's kids playing on a pile of dirt, hey, you guys need to get out of here. We're going to contact the authorities. So protecting yourself from theft, protecting yourself from that liability is huge. And as I mentioned previously, we've held strong with a 98% deterrence rate, proactively stopping that unwanted activity from progressing to next stages. So, yes, I'd be more than happy to answer any questions that you guys have surrounding that kind of product or anything. But we'll start our Q&A right here. And we did have one pop up. So we had copper wire stolen twice from a fenced site. Could that be seen as a foreseeable risk under negligent security?
I'm envisioning in this scenario, like the owner's having to, go after the GC for that cost and is claiming that the GC was negligent in securing it. After those first 2 times, it might be kind of hard to prove that the GC was negligent. But certainly if something like that has happened twice, then in my view, whatever measures are being taken need to be increased at that point. And if they're not, then, if I'm representing the owner and we're going after the GC saying you didn't properly secure that site, I'm certainly going to use those first 2 instances to say, hey, it was foreseeable that this would happen a 3rd, 4th, 5th time, and you were negligent in not addressing it.
Does Cloudastructure have solutions for fixed cameras as well? Yes, absolutely. So we offer fixed cameras, fixed speakers, the whole shebang. We're camera agnostic, so we can even work with existing cameras that you may already have on site. We can work with 99% of existing IP cameras. But that being said, we can go in and do a full security audit of the property, of the site, and determine what solution makes the most sense, whether it's fixed or mobile. What is the challenge for not having 100% ability to respond in a situation? And is there something the owner can do to eliminating not seeing 100%?
I guess the challenge is that's not going to create it's not going to create liability. It could stand, as we were talking about, eliminate liability because you disrupt a theft mid progress or a trespasser mid trespassing such that they don't get hurt or end up stealing something. That's going to obviously decrease your liability. But as far as not monitoring the cameras, like I was saying with Jen, it just comes down to kind of practically, are you going to be chasing someone for stealing something, or are you going to potentially stop the theft from even occurring? So it wouldn't necessarily affect your liability. And, as far as an owner's inability to monitor the cameras the whole time, about the only thing you could probably do is to eliminate that that is monitor them full time. Again, the law is not expecting that to happen. That's why I'm saying it's not going to increase your liability, but just as a practical standpoint, saving owners and GCs money, headaches, future losses, certainly, having cameras and having them monitored timely and real time is going to just reduce your ultimate potential risk following a theft or an injury.
All right, another question from Q&A. Do we have to request footage for review, or can we access it ourselves? In the past, we haven't had access to the footage, and it takes days to receive the incident recordings. So with Cloudastructure specifically, you have access to all of the footage. It's a cloud-based system, so you as a user are logging into the cloud from any mobile or web-based interface. You can log in from anywhere, from your phone, from your couch, and you have access right then and there to that footage. It's stored in the cloud for 30 days. You have the ability to save it for longer. So especially for instances like this, liability, an injury, theft, trying to hold someone accountable for property damage, there are ways to save that footage for longer so you can have it for those court cases down the road. And in the past, we haven't had access to the footage, and it takes days to receive the incident recording. So yeah, you have access right off the bat. And then in addition to that, you can also utilize our support team and leverage our support team to put together a playlist for a specific event that happened on property. We know how much time it takes to search through footage. So we actually have a really cool feature that utilizes object tagging. So you go to the page where all the footage is stored, you type in a tag word, and right then and there, it narrows down the footage that you have to look through that has that specific tag word. So you can search for person, you can get color specific in terms of color of clothing, color of vehicle. You can get specific in terms of package or whatever it might be that you're specifically looking for. If there was a trespasser and they were holding a backpack or carrying a backpack, you can type in backpack. So the searchability is quick, easy, saves so much time. But again, we have a support team that will also help you put those playlists together for that footage. Any other last final questions, go ahead and throw them into the chat. Otherwise, you should see up on your screen a poll that asks if you would like a personalized demo of our AI surveillance and remote guarding system. And also, if you'd like to go ahead and register for our upcoming webinar that will cover trespassing on property. So go ahead and fill out that poll. Any last questions, go ahead and throw them into the chat. Otherwise, it looks like our next screen will show our upcoming webinar. And then you have both mine and Adam's email. If you have any final questions that you didn't have a chance to ask today, go ahead and write those down. I'd be more than happy to connect with any of you guys today if you have questions. And yet again, Adam, we're so appreciative of you for joining this webinar and offering your expertise and your stories. You have a wealth of knowledge to share, and we're so grateful.
Thank y'all. Glad to be here.